Talks, which is the first session of this year. Welcome to all of you. And for those of you who are not familiar with our AITPT webinar series, AITPT is an initiative that we launch at our Digital Law Center that has the mission to offer a forum for discussing cutting-edge AI tech and policy issues and for fostering an interdisciplinary and global dialogue about these issues. And we're very happy to have outstanding speaker and commentators that I'll be introducing to you in a second, and who come from various backgrounds and also from geographic areas, with Alina Trapova in London, Stacey Chuvaieva in Chicago, and Philippe Sundfeld in Sao Paulo. So we're very happy to have them, and we already thank them very much for spending this session with us today. So Alina Trapova will be our speaker today. She will address the very hot topic of gaming and AI. Dr. Alina Trapova has recently been appointed as a lecturer in IP law at University College London, UCL, and she is working on various AI-related research projects, including one on the very topic that she will present today, i.e. legal issues arising from the use of AI in the video game industry. And as those of you who have already attended sessions in the past of our AITPT series, the presentation by our speaker will be followed by comments made by distinguished commentators. And today we have two great commentators, starting with Stacey Chuvaieva, who practices entertainment law at a US law firm, Mitchell, Silberberg and Knupp. And she's now in Chicago. She graduated from Harvard Law School last year, where I had the privilege to interact with her, has worked in the gaming industry, and works on the PhD project, our own law school. And we also have the great pleasure and privilege to welcome Philippe Sundfeld, who is Senior Manager, Legal and Data Protection Officer, DPO, at Wildlife Studios in Brazil, which is, as some of you may know, one of the 10 largest mobile gaming companies in the world. And Philippe Sundfeld is joining us from Brazil, from Sao Paulo, but he also has Geneva connections, which is great, because he's an alumnus of our joint WIPO University of Geneva Summer School in IP from the year 2014. And as you know, those of you who've attended past session, the idea of this session is really to engage in a discussion with our speaker and our commentators. So we'll open the floor. So do feel free, all of you, to speak up, either by, of course, raising your hand, as you're familiar, sure, on the Zoom platform, or by using the chat if you want to make comments or make other statements in the chat function. Please note that the session is recorded, and the plan is for us to make it available on our website so that the people who could not attend today will have a chance to watch the session later. And before we shall start, we just wanted to immortalize this moment by taking a picture. So I would invite all of you, if you can and if you want, to turn on your camera so that we can take a picture before we shall start the session.
Perfect. Thank you very much for turning on your cameras. For those of you who can, I'll be taking the picture in 3, 2, 1. Brilliant. Thank you very much.
Thank you very much, Amjud, for this and for all your help for this session. And now, without further ado, I give the floor to Alina Trapova for the presentation so that you can share the screen. Thanks very much.
Okay, you should be able to see my slides now. Thank you.
Yes.
Yes. Thank you so much for the very kind invitation, for the very kind introduction. It's really great to connect once again and to actually meet people who are interested in AI and gaming and IP. So I will not spend more introductory words, but I'll just dive straight into this. So the topic of today is AI and gaming, but I would like to focus on a few more narrow aspects. It's a very big topic. It's certainly developing, and what we will say today is certainly just the beginning. I would say of this very big and exciting discussion. So it will touch upon various aspects, and at the end I will actually point to some further directions where this can develop. So I hope this is a good conversation that we start and we will maintain. That's the point I wanted to say. I would like to first position a little bit video games in context. So they are the area of video games as a creative industry is particularly profitable. And I'll show you a few numbers. Then we'll look at video games as a subject matter. And then I will start tying a little bit more this discussion to AI and creativity. And at the end, I would like to spend several words on a specific case study on one. I would like to say it is a video game, but it's more of a tool, more of an interactive tool, and show you how actually AI has started impacting video games and the way that this will develop further and touch upon various copyright law issues. Obviously, we can open this up to other types of IP rights and beyond, but in the interest of time, I've limited myself to one aspect. So a very, very profitable industry indeed. This is a report from WIPO. It was published last year, if I'm not mistaken. Now with the pandemic, the year started muddling together, but it's certainly very, very recent. And it basically puts video games on top of profitability when it comes to the creative industries. So in 2020, the industry generated $178 billion, and there has been a significant increase since 2007, when actually when the iPhone was launched, so when mobile actually became a thing. And here, Philippe would actually be able to say a few more words than I on mobile. In 2020, the revenues generated in the video game industry exceeded those in film, books, music. You have the numbers on the slide. Now, one may say, sure, this was the year of the pandemic. It's not very surprising, but this has been a very, very constant trend. The pandemic boosted it further since everyone was stuck behind the screen at home for many months. But this has been a trend for quite some time now, and it still continues. Now, video games as a complex subject matter. The legal systems have struggled to basically characterize video games as a subject matter. Depending on the type of jurisdiction we have in front of us, the answers have varied. And in fact, there is another very interesting WIPO Commission study by some colleagues from Queen Mary University. I'm happy to give the reference later, where they study the legal nature of video games, and they just point to the fact that exactly very, very different answers are given depending on the jurisdiction. Nonetheless, this is a reference from a case from the Court of Justice already quite old, more than 10 years ago. The Court of Justice in the Nintendo case told us that video games are complex. So they comprise, of course, not only just of a computer program, but also graphic and sound elements, which have a unique creative value. So the court started appreciating this complex nature, and this was all tied to how we actually position video games when it comes to a legal regime, whether we would treat them as entirely computer programs, which will follow one type of legal regime, the Computer Programs Directive in this specific case, or whether we would treat them as something different, something more. And the court told us that they are something more. At the time, AI was not a thing. And at the time, actually, it became even though the court seems to be clear when we read this paragraph, academia was not entirely convinced that this is such a straightforward answer. So there were some colleagues arguing that, well, they are in fact a computer program and something else. Well, others argued that we have to basically look at the whole thing together. Now, AI, as I said, was not a thing there, but this already started steering very difficult discussions because the legal regime would differ depending on how we look at the subject matter in front of us. Another way in which I would like to contextualize video games is by looking at them as a vehicle for creativity. So we have several potentialities for creative output when we look at video game. The literature has divided this in terms of successive creativity and something called in-game creativity. Now, successive creativity, we have seen a lot of examples when it comes to user-generated content, fan fiction, streaming, all of these platforms and video game streamers and influencers that have generated quite a bit of revenue and popularity in the past years have been thriving on successive creativity. An interesting study carried out not too long ago by Amy Thomas at the Create Centre at the University of Glasgow studies the different policies that video game companies actually develop when it comes to user-generated content and this successive creativity. So she studied 30 popular game titles and identified 7 different types of user-generated activities. And it's a very interesting trend in the gaming industry, which one can distinguish from that in the film and the music industry. Companies are more permissive with respect to what seem to be more permissive. I don't want to make a very big claim here, seem to be more permissive as compared to the film and the music industries, the other more traditional creative industries. And it appears that looking at these contracts in terms of service, she concludes that it is an almost Creative Commons style system of user enablement. Obviously, there are some limits, so the study, it's empirical, so it is very interesting, and there are further findings on the basis of these games that she has studied. But developers appreciate, and in general, video game companies appreciate that users are important. So creativity that comes from their product, the successive creativity that the users thrive on is essential for their success as well. So they can't alienate their gamers. They can't alienate the people who actually appreciate their product. Obviously, these contracts are not extremely generous, not to the biggest extreme, but they are more permissive as compared to what we have seen traditionally in the creative industries. Now, what I'd like to focus on here is what we call in-game creativity. So whatever a user, a gamer, actually can do within the game in order to reflect their creative efforts. And here's where AI's role steps in very, very prominently. Oops, to the next slide. Okay, so This has not been not been left unnoticed by the European Commission and by the European Union in general. This very recent study from 1 year ago from now looked at the impact of AI on the different creative industries. So this was focusing on video games, but also architecture, book publishing, fashion, film, music, and so on and so forth. Many benefits of AI were identified, but interestingly, one of the benefits was inspiring human creation. And this is important because there's been a lot of talk about machines substituting humans and taking over, and many of these things have been exaggerated. Others have been more cautious, and I don't want to take a strict stance on these, but it is important to highlight that AI can be an enabler also of human creativity and human creation. And I'd like to show you one example here today with my small case study. Within the context of video games, the way that artificial intelligence actually works mostly is when it comes to procedural content generation, or PCG. These are the so-called adaptive games. So artificial intelligence systems are incorporated within the game to help actually generate ever-changing content in the game. Different levels, different maps, different characters, which are importantly not coded by the developers in advance, predetermining every single aspect of these, but they thrive on machine learning models, on artificial intelligence models. Now, I'm not digging into the technology here, even though I am a strong believer that we should really approach each project on its own merit and actually try to understand how the technology works. But this is not the point of this presentation. That's a topic for another research, but it is an extremely important point. So I don't want to overlook this. The benefit in general of AI, of using AI for video games in this specific context, are many, including enabling human creativity and pushing forward creativity in general. But it also is tied to the fact that development costs are reduced, which brings a little bit the fear of, are developers going to be out of job because AI will be creating instead of them? But that again is also a discussion we have had when it comes to other areas, but also it helps us actually to extend the shelf life of a game. So the fact that the setting can constantly change and adapt to your gamer's behavior makes the game more exciting, makes the game different every time one is playing it. Now, all of this can be implemented into different games within different storyline, and you can see already that the potential is huge. So my focused case study is on this text adventure game called AI Dungeon. Some of you may know of it, others may just discover it, and I would encourage you to play a little bit with it afterwards to test it. What is this? Basically, it started as a startup in 2019 by a US company. So it is, how to put it? It is a text adventure game which generates storylines on the basis of user prompts. Now, we have heard a lot about prompt engineering, generative AI these days. And this is where generative AI starts interacting with video games and intellectual property at the same time. So the point of the game is very simple. The user interacts with the software in different ways, in 4 specific ways. And eventually, the final product of this interaction is a story. And I'll show you what I created the other day when I was playing with it. The system allows the user, so it actually works perfectly. The free version on the web browser is what I did, and you can all test it very quickly. First, the game allows you to pick a setting. So I picked fantasy, just to tell you where my story ended, which I will show you in a second. Then you would have to select a character. You're given several options. This is the free option, the free version of the game. Obviously, once one becomes a member and subscribes, there might be more possibilities. I picked a princess. Then one has to pick a name of their character. Well, I thought of Princess Leia, so I called my princess Alina. So it starts a little bit with my name. Then I was given these first few lines that you currently see on the slide. This was generated automatically by the system. You are Alina, a princess living in the kingdom of Flareon. You wake up in a big feather bed and hear clamoring outside your door. A knight rushes to tell you that the king and the queen are in danger. You throw some clothes on and rush out of your chamber to see what's going on. The courtyard is in chaos. And here you see a little bubble underneath where you can decide whether you pick an action, so do, say, see, or story. These are the 4 options that the game allows you to use. So I went easy and I said, do. So I made my princess climb on the closest tree in order to see better. This was my prompt. And then actually the algorithm on the other end generated the short text that you see. You climb on the nearest tree in order to have a better view of the battle going on below you. So it didn't necessarily use exactly my words. It kind of turned it into some slightly different, more attractive narrative, I would say, but it kind of kept the same idea. Now, I'm not going to keep reading all of these things, but then I made my princess say something, and then she said it, and then the system generated a little bit of a text underneath. What I'd like to spend a little bit more time on, because I know I'm a little bit pressed on time probably, is the see function, and you will understand why. So your character can do things, they can say things, you can just generate a few lines of story without any action linked to it, but they can also see things. So I made my princess climb on the tree. She said a few things, and I wanted her to see what is from that top of the tree. So I made her I generated this image, which is, I typed a medieval castle surrounded by a forest. Now, those of you that are huge fans of pixel art would love this. It's not my thing. I appreciate it, but you can clearly see that this is, those of you that know a little bit about pixel art will appreciate it. This is a decent medieval castle surrounded by a forest in pixel art style. This is how the entire screen looks like. And here, I kept this to show you a few options. So if you can see on the top right, this is a few tweaks that I can have in the system when all of this interaction goes on. This interaction can go on as long as I want. And I can insert prompts, the system replies, and then we stop whenever I decide. Now, I can actually influence the AI writing style with several directions. The example given here is that the AI, in responding to me, can use very descriptive writing in the style of the 17th century language. I can incorporate several important memories, several important facts within its memory. So I can tell it to remember that there is a troll king who lives under the great giant mushroom in the forest, and that may actually crop up later on in the story and be brought by the AI once I prompt it with various things. And in addition to the text and AI aspect, here is something interesting about the images. Now, I used the free option, which was the pixel art option. If I were to subscribe, I could opt for stable diffusion images. These are high quality images, and they have been quite a bit in the news. So Stability AI is a UK company which basically generates a lot of, which developed a software to generate images on the basis of machine learning. So this image can actually look differently if it uses a different AI model that was actually incorporated here through stable diffusion. Now, a few words on the copyright aspect, and then I might actually have to stop. I'm sorry if I'm running a little bit over. I'm starting to wrap up. What are the copyright issues here? Authorship and originality are things that will keep cropping up all the time. And these are the issues related to the final output. Now, I have been interacting with the software for a certain amount of time, who actually gets to own, who is the author of our final story. And by the way, Dungeon AI is something that you can play in multiplayer version online. So imagine being several of you online interacting simultaneously with the AI. We have potentially two options here in terms of a human author. And when it comes to originality, I just want to paint the big picture. The do and the say options may be too little for originality in copyright to subsist, regardless of which standard we're talking about. Here, I have used the European Union's approach. The story option, where I actually write a text myself, and if the text is sufficiently long and it reflects my own intellectual creation, it may pass the threshold. Now, a lot of question marks are surrounding the C option, the image generation aspect. Are my prompts sufficient enough for an intellectual creation to subsist? Is there going to be originality just in the prompts or in the image on the basis of my prompts? We need to dissect the diffusion models, which is something that I said I'm not doing because I don't have the expertise. And finally, something that links me to what Amy has been doing, Amy Thomas at Create. We need to look at the contracts. We need to look at the license model. The stable diffusion thrives on a very permissive open source model, but they're currently in court. They're currently in court defending a case in the US as well as in the UK. The case is related to the input aspect, so there's lots of questions related to text and data mining, which are some of the potential further issues for discussion. We can talk a lot about patents and non-player characters when it comes to video games, and we can talk also a lot about terms of service, trying to kind of circumvent these difficult IP questions. I'll stop here. I'm sorry if I overrun a little bit, but let's have a discussion.
Thank you very much, Alina, also for introducing us to Princess Alilea. I like very much the idea. I look forward to the next adventures that will happen to her. Without further ado, I'll now give the floor to Stacey for her comments.
Thank you so much. Thank you so much, Professor Trapova, for the really interesting discussion points. And I want to revert back a little bit and first discuss the general impact on the industry, because we saw really interesting examples of how AI can empower players, but it's also interesting how AI can empower the industry itself. Then I want to touch a little bit upon the litigation and the GitHub case in the US. The Stability AI, they also incorporated in Delaware, and they're currently facing litigation in Delaware against Getty Images filed a lawsuit against them in Delaware. And one of their really strong arguments, as they believe strong arguments, are that it is a fair use to analyze the huge amount of images available on Getty Images website and train their AI on that samples. So we want to discuss a little bit that topic, because it's really interesting whether it can actually be a fair use in the US or in the UK. And also it's really interesting, what is the standard of originality when we talk about AI? So coming back to the fostering human creativity, which was a really interesting point. And when I saw that, I thought well, how come AI foster my originality if it sort of replaces me? And it was a really interesting example how it can help the player throughout the game excel and see the images generated through the text input. That was a really interesting example. And the other interesting use that can be unexplored for now is how it can empower small studios. We see that the industry itself is being monopolized, and Microsoft is buying whatever can be bought on the market. And it's super hard for small studios, so-called indie video game companies, to enter the market and basically embody their interesting ideas into the cover of the game that can be appealing to the user, because users get used to the really high quality standards and AAA games. And if you have a genius idea, but the quality of the graphics or the art in the game is not high enough, players will not just buy your game. What AI can do instead, it can help the small companies to bridge the gap of the high quality in terms of art production, and at least save money in this way, and give way for their creativity and just express their idea, paying less for the basically producing all this art. However, for bigger companies, whether it's mobile or PC games, the problem is that the company will not easily replace their 300 artists with an AI for several reasons. The first one, they cannot register copyright, at least in the US. So technically you can register copyright with the images created by AI, but Copyright Office in the US made it clear this year that these images will not be covered by copyright protection. So if your game has AI generated art, this will not be protected by copyright. And for many companies, it's a no-go. The other problem is the IP audit. I was on IP council 2 years ago in a video game company, and I sort of was like a road bump for our development team, because every time they came up with a genius idea, whatever it was, it can be NFT or use of AI, IP lawyer is usually the one who says it's a no-go because we have an insurance. An insurance company will not be happy with us using AI trained by Getty Images, still having Getty Images logo and the art produced by AI. And here we go to the question of how dangerous it is, and dangerous, what is the risk of using AI? The problem is we don't really know what algorithms are used, right? We don't know what information is collected and how it is used. So in a recent litigation that I mentioned, Getty Images was a Stability AI. Stability AI claims that it's a fair use, that they train their AI on a lot of images, but what is produced is not a derivative work. It's an original new creation, and it's completely covered by the fair use. So here is a really interesting question. Can it be a fair use if it's a market replacement? So many cases cited by AI, Stability AI, and supporters of AI implementation, including the video game industry, is that, look, it's a fair use because we have several basically well-developed doctrines in terms of for instance, Authors Guild versus Google, where Google was doing something very similar. They were sort of pre-reading, pre-scanning a lot of books, and then you had that book preview function in line. And the Second Circuit found that it was a fair use, even though the Second Circuit said that they were trying the boundaries of fair use. What is interesting is how Delaware, the Third Circuit, going to interpret this decision and address it, because it's easily distinguishable on the fourth factor of the fair use. Stability AI can replace the Getty Images services on the market, and that's what they can do. So in terms of the effect on the potential market, it will be crucial, because if it's so cheap to generate AI image, who would go and buy this image and Getty Images? And it's really interesting how this will evolve and how the court will address this. But I would say the IP scholars, a little bit skeptical about the fair use defense for the use of AI, even though the industry is really excited and they hope that they can extend the boundaries of fair use to basically cover this type of training. We also see an interest in litigation initiated by authors like Anderson versus Stability AI, a lawsuit filed in California Northern District this year, where authors basically say that what AI is doing, they are ripping off their creativity, they scan their works, and they just create a collage of the images created by authors without giving any attribution. So one of the claims that they make is the section 1202, basically misrepresentation of the copyright management information. So they remove all the watermarks from Getty Images, they remove the authors' names from the images created by authors like Anderson, and they just produce you the image, which looks like it was created by Anderson, but you will never know because you don't see the copyright mark. So these questions are really challenging and challenging both the boundaries of the fair use and the question of like, what is creativity? Because the standard of creativity in the US is pretty low. Basically, any sparkle of originality already suffices for creative work. So the question is, was there a change in several elements? As we have seen on the image showed by Professor Trapova, two football players slightly changed is not a derivative work, but an original one. So the question is it an original work? What was changed there? And whether this change is sufficient to basically to be deemed as an independent creation and not as simply a derivative work. So all those questions are really interesting, and it's interesting to see how the industry will react to those and how industry will use AI, keeping in mind all these potential risks. I think that a lot will depend on the outcome of these litigations, but it also will depend on how monetarily the industry will be interested to implement AI and what are the possible uses. So I think maybe Philippe can tell us a little bit more about how mobile industry and the wildlife studios like envisages the further potential use of AI. Are you considering this? Do you already have questions from your development teams, like how we can use this today?
Thanks very much, Stacey. Before giving the floor to Philippe Sundfeld, Alina, would you like to react to some of the excellent comments made by Stacey?
Sure. So many interesting things, but one thing that to pick a little bit on the fair use point that you were making. So it's very interesting to see how the different countries will actually also approach this from national policy perspective. I see how it can be important and interesting from a video game company perspective, but it's also everyone these days feels like everyone wants to be the leader in AI. So when the UK left the EU, they issued their national AI strategy and they said, we want to be the superpower in AI now that we can do whatever we want with our laws. Now, very recently, I think it is from about 10 days ago, no, December 2022, so just two months ago, the Ministry of Justice of Israel issued an opinion, a statement on the use of copyright material for machine learning. And they also say, rightly so, that they are leader in the production of AI systems. So in that very long opinion, which I admit I haven't read thoroughly because it's something very, very long in pages, they argue that this is fair use. And the official position of Israel is that this kind of use of works for machine learning purposes is fair use. And the laws of Israel are very similar in that respect to those of the US because they have a fair use and they copy pasted the same provision and they even refer to the US case law. So that will be also a question of how the countries will seek to stimulate their AI industries within their boundaries. So it feels like what they are trying to do here is also very similar to what the UK wanted to do, but is no longer doing. So the UK was on the road to adopt an all-purpose, no opt-out text and data mining exception, which would have been very appropriate for the same purpose. There is no fair use in the UK. There is a text and data mining exception, but it's very, very limited for only non-commercial research purposes. But again, riding on the wave of we want to be the AI superpower of the world, let us adopt a very wide sweeping exception to copyright infringement. This is no longer happening here. It's currently in the UK, it's currently on pause. But that's also another perspective to keep in mind. I'll save my other comments for afterwards to see what Philippe has to say, because I'm super curious of his position too.
Thanks very much. Now to you, Philippe.
Brilliant. Thanks, Professor De Vera. Well, I must say I feel at home as alumnus from the summer school. I'm excited to be here. It's been a turning point in my career, so I'm grateful for almost 10 years later being here in the same virtual room, talking about gaming and AI. I do have a few questions for Dr. Trapova and general comments. So I'm just gonna lay them out there, and please feel free to address them in any way you like them. First, I loved Stacey's provocation and your answer about actions and how IPOs and different markets in different countries are approaching it. I find that the UK IPOs example is quite interesting about the use of the text and data mining exception as kind of like a vector for pursuing public policy in that regard. I know that the IPO has been reallocated somehow in the UK, and maybe that's led to kind of like a shift in perspective. So I'm wondering what are your thoughts in terms of like the future for that in now having AI as a factor to consider. But then coming back to I guess my comments, I would love to add maybe another layer to the conversation. So Dr. Trapova mentioned user-generated content and in-gaming creativity, and Stacey mentioned how the industry is reacting to it and how it's changing the industry. And Stacey, answering your question about how mobile gaming companies are addressing it, I can't speak for my company, but I can speak for the general sense, I guess. And to kick off, I think that the main preoccupation really with mobile gaming companies, every mobile gaming company in the world is likely looking at AI as a means as a way to increase efficiency, right? So creating mobile games is getting more and more expensive. I was listening to an art director the other day saying that you're pricing the same to players, but games are getting more and more expensive, and there's more and more competition. When you're trying to cut costs, AI is a gift. AI is a gift from heaven. When you're trying to cut costs in terms of, like if you think about it, you're designing a character's hair. It's time consuming, right? Artists don't like doing it. Like doing hand animation, it's time consuming. Everything's time consuming. If you're talking to data scientists about understanding who's a cheat in the game, understanding unusual spikes in activity, all of that is time consuming. And if you have AI, if you have tools to cut shortcuts, it's definitely a gift for a company. Artists don't see it that way, and IP lawyers, as Stacey mentioned, don't necessarily see it that way. But from a legal perspective, I'd say that there are very particular preoccupations from a gaming company perspective. When you're using AI tools to create content to create games, you're using it. So the way that it works for those that haven't tried, you use generative AI tools, which mean that you feed the AI tool with information, with a prompt, with an image, with a direction. It runs from its algorithm. It runs from the training material it had, the billions or millions of pictures or of data. And you have an output, and then it kind of like delivers something else to you. So something that has to be considered is that you're using different tools for different. A game is comprised of different tiny pieces. So you're talking about code. There's an AI tool for that. So you're talking about code, you have a tool by Microsoft called Copilot, which is an extremely interesting tool for our discussion. Copilot is a tool that you kind of use as a chatbot, so it predicts the code that you wanna write. So you input an instruction and it kind of like codes it for you, but it does use open source code from GitHub, which is the largest open source resource for coders. Naturally, coders were unhappy. If you're talking about artwork, you're talking about animation, you have Midjourney, you have Stable Diffusion. If you're talking about sound effects, you can also have other tools. If you're talking about dialogue, you can also use ChatGPT. If you're talking about different parts of the game, you have specific tools. Each of those tools, you're talking about different subject matter from a copyright perspective. And I guess you run into the interesting point of view of how to avoid infringing third-party rights. And then here you get into the discussion of exceptions, right? I mean, it's not common for you to have, naturally, when you're talking about gaming, you're talking about genres. So you have different genres. Each genre must have, key games that are recognizable for everyone, and your artists are going to strive to do something that might be similar, or that might, be recognizable in that field, might be innovative in that field. When you're doing it, one preoccupation is not to infringe someone else's right. This is hard to do, and this is where I guess the discussion on fair use gains ground. I mean, naturally, fair use is a conversation that's appropriate to have in the US and in countries that have that line of exception developed. One preoccupation for gaming companies is that if you're talking about mobile gaming companies, you distribute your game in 200 countries. You have developers around the world. So you're dealing with different markets. You're dealing with markets with different legal traditions. Not everywhere will have fair use as an option. If you're talking about the UK, for instance, the discussion goes from fair use to fair dealing and to the text and data mining exception, which has a limitation of being maybe appropriate for scientific works only and not for commercial use. So that's a main. When you're talking about the input or the stuff that you fit into the AI tool, avoiding infringement is one preoccupation that I don't think that anyone has a clear answer yet. I'd love to hear your thoughts. But then if you're talking about the output for a mobile gaming company, you're also thinking about, depending on the input that you've chosen, the resulting work. As Stacey mentioned, is it an original work? Is it a work protected by copyright at all? Is it a non-authorized derivative work? So you're using someone else's work and you're respecting, you don't have authorization or license to use their work, and you're running into trouble. Some interesting aspect here that I don't think is discussed all too much is the role of parity and pastiche. It'd be brilliant to see Dr. Trapova's thoughts on the role that the role of parity and pastiche would have in that discussion. But then supposing that it is your work, your original work, that discussion on authorship and ownership is extremely interesting, especially for companies, large companies, where you're having different departments creating different tools. I mean, again, you have work for hire in the US. Considering that, even just taking into consideration the hypothesis that you'd have an original work. So who owns this is an extremely interesting discussion for mobile game companies. But I'm sorry if I'm running out of time and going too far. But then I guess we end up in the most exciting ground for discussion for gaming companies, which is litigation. Gaming companies love to litigate. Market leaders love to litigate against indie studios or competitors. It's a war zone, and it's interesting to see whether gaming companies are actually going to war over content that's being developed using AI. They're very prone to litigation, AI gaming companies, and That's extremely challenging, isn't it? I mean, you have to prove access. If you want to prove that someone has used your work, how do you prove access? When you're talking about AI tools that have databases that aren't accessible to the public, you don't really know. If you're talking also about gaming company, there's a huge amount of fan fiction available online. So you don't even know if the third party has access to your original work or a third party's fan fiction. Proving a casual connection is extremely hard. And then if you're talking about, proving that someone's copied a substantial amount, a substantial part of your work, I think it's going to be a challenge, isn't it? How do you do that case-by-case analysis, and how do you prove that, from a qualitative perspective, the work that's being copied and added to the AI tool was substantial. So, input, output, and litigation, breaking into those three pieces, there's lots of ground to cover. I don't think that anyone has answers in the gaming industry for all of those aspects. But what's interesting here, and Stacey has mentioned litigation. I'd love to hear Dr. Trapova's thoughts on the role of courts in kind of like defining the boundaries and shaping the discussion in the near future. We're already seeing litigation mostly against AI tools and the companies behind those AI tools. But I guess it'd be interesting to see your thoughts, Dr. Trapova, on how courts can decide on the role of exceptions and so forth.
Thanks very much. Here again, wonderful thoughts and comments also coming from the ground and from, as you were saying, the war zone, perhaps litigation, which is always an interesting topic to discuss. Turning to you, Alina, I'm sure you have comments, reaction, and perhaps yourself questions to address to Stacey and Philippe, and of course to the audience too. Alina.
Of course, thank you. I was wondering when these cases will go to court, and I was having recently a conversation with a colleague, and we both actually were a bit shocked that it took so long. We don't know. I don't know why it took so long. I haven't spoken to the lawyers yet. I'm hoping to do this soon. But our guess is that they were preparing. They were waiting for a while to see how actually, because these technologies develop very quickly. I remember I came across Stable Diffusion for the first time during the summer that passed. I think it was born a little bit earlier, but then it was perfected in Munich at the LMU, and then when it started collaborating with Dungeon AI, it was a very basic collaboration in the beginning. And then suddenly I saw that things exploded very quickly. So I was wondering really, when is it that they are going to sue them? And why did it take so long? So I think on the role of the courts, to pick up the last comment, it will be interesting to see how the courts will respond to this. And we're lucky in the respect of, not lucky that people are litigating, because that always involves cost and time. But we're lucky to see similar cases currently being litigated in the US and in the UK. So unless they settle, which is a very big possibility in my personal view, we might actually get some insights on how the courts will handle this. The courts will have a role because the law is not clear-cut here, especially in jurisdictions when you have fair use. In jurisdictions where you have more limited exceptions in the context of text and data mining, where you don't have an open norm such as fair use, the situation will be a little bit clearer. So I'm referring here to the EU countries, which following the 2019 directive on copyright and related rights in digital single market, now must introduce two exceptions on text and data mining. The first exception is only for the purpose of scientific research and cultural heritage organizations, while the second one is includes also commercial purpose. What is, however, limiting here is that for companies that deal commercially, is that second exception allows for an opt-out. So it's a non-mandatory exception, meaning right holders can derogate from it contractually. And right holders will derogate from it contractually. I had a look at some of the responses in the public consultation that was carried out here in the UK with respect to text and data mining. And many companies who actually, the consultation was rather broad, it was broader than text and data mining, but those that actually replied to the text and data mining questions and the proposed reform said that they will opt out. The question was something like, do you have experience with the opt-out in Article 4? And if you do, how do you handle it? Well, we do, and we opt out, or we don't, but if we do, we will opt out. So the answer was clear, that right holders are aware of this. So it will be a little bit useless for commercial purposes, which takes me to your question on the text and data mining, the future of this exception. Here, I think it's completely frozen from what I understand now. It is completely frozen in the sense that they went very bold. The consultation did not actually provide a very conclusive response on text and data mining. I think around 60 responses came through from various types of parties, from right holders through users, academics, and so on. And when they concluded the consultation in June last year, the government said that they will totally reform the text and data mining exception and adopt a wide, mandatory, non-opt-out exception for all purposes. So yes, we want to be the leader in this AI industry. I understand that there was a huge backlash from the book publishers as well as the music industry. There have been very, very strong criticisms once the government announced its position. And then there were a few discussions, and the final position is they're not going forward with it. I don't see them going forward with it at the moment. I think already quite a lot of resources on consulting were spent, and the UK IPO hasn't found any conclusive answer. I think maybe licensing might be enhanced to the extent that actually is needed. That was another alternative in the consultation, to actually enhance and ease, facilitate licensing for text and data mining. But only time will tell. Things seem to be happening and changing very quickly without too much rationale behind it. On substantial copying, when you were talking about it, again, something I read in the Israeli opinion resonated with that. So on top of using fair use as an exception, the opinion refers to incidental use and transient uses. So if it's not fair use, the Ministry of Justice of Israel says that it could be either incidental uses of copyrighted works, or if the databases on which the system is trained on are deleted and are used for the sole purpose of that project, it could be transient use, which is an interesting argument to make. I think we have that exception in all countries, if I'm not mistaken, at least in Europe, and it is interesting to see how that will be argued in court. It's not an exception we see very often. I think the last time there were big things happening around it was when the internet came around, and they realized they needed an exception of that kind. So we'll see. Do I go on? Okay, so
Sure,
a few words
sure, please.
on parody and pastiche. Again, I have a no answer, but that's a very good point. Again, we have no idea what pastiche means, aside from a few very prominent and excellent academics having written books and articles on it, but we have no idea what the courts think pastiche means. I was talking to an American friend yesterday, and he said, I only learned about this thing called pastiche when I moved to the UK. So apparently, well, of course, the US has fair use, so it doesn't need to enlist its exceptions in such a detailed manner. While in Europe, in the EU, we have caricature, parody, and pastiche, copy-pasted from the French copyright tradition. So it might be interesting. There are people arguing that pastiche will become more prominent over the years, not only in the context of AI, but various types of new works that are being generated. The discussion started with sampling, appropriation art, and it hasn't been properly tested, aside from, I think, a few decisions in France. Final word I would like to say on the output points that you were making. So yes, so text and data mining is one side of the story. The output, which I was talking about in my presentation, is the other. They are connected, but depends on the jurisdiction. And a work could be infringing and copyright protected at the same time. So the fact that it includes infringing material doesn't automatically derive its originality as a new work. So that will be interesting to see how it plays out in the different jurisdictions that the cases are litigated in. The difficulty, I think, is that this is a global phenomenon, and we will end up with one approach in one country, again, following their own system, and then another approach for another jurisdiction on the basis of their own copyright laws. But this is a very, very old problem that we have had in copyright for years. So until we agree on a universal international copyright law for everyone, which is probably not going to happen, we'll still continue having these issues. I stop here. Maybe the others want to say something too.
Thanks very much, Alina. Would you like to react, Stacey or Philippe, before we open the floor for potential questions or comments from the audience? Stacey?
I think I have several follow-up comments, and thank you so much for such an interesting discussion. One of the interesting points to me is the separation between like the fair use defense for the data mining and basically training AI, if we're talking about like Israel or the US, and the infringing output. So the fact that training AI might be AI is questionable but true, but when we see the outcome, as in the class actions recently filed in the US against the GitHub and Microsoft, whereas the question is like, okay, but the output is infringing. Authors can actually find lines of their code in the output, and they say, well, but that can't be fair use because you just copied part of my code, and then can even argue basically fragmental literal copying in words of Nima, right? They can find part of their work being copied. So the question is, first, in theory, can training AI be fair use? And I agree that it might be, and it also like a question of policy, but then on case basis, when we see that the result of this training is a copyright infringing derivative work, or simply part of like literal copying of someone's code from the GitHub. So that's a little bit different problem. It can be solved by development of AI. So when after training, AI will not be just mixing lines of code or different images to create like allegedly original work, but when AI will be sophisticated enough to generate creative work which will not be infringing, then it will also widely used by the industries because the risk of the litigation will be lower. As a video game company, I can more or less be sure that when I use this image, okay, I don't have an indemnity in Stability AI terms of use, right? But I know that the practice shows that the outcome is pretty original, and I won't have a lot of litigation stemming from this use. But if I see that for now, it's really looks like a mix of whatever AI saw during his life, it's pretty dangerous in terms of the outcome, which is almost 100% infringing. And Philippe, I see you unmuted. You want to say something?
It's an extremely interesting argument. You mentioned the last type of the fair use test. I mean, like whether it hinders the market from the rights holder. But then what I'm also interested in is the type of being transformed, whether the use is transformative or not. And if you're using copyright protected work to train an AI tool, whether that's transformative or not, it'll be an extremely interesting topic to see being developed in the court in the US.
Yes,
which
I agree.
is sorry, just your comment just clear it out for me, and that would be so interesting for the industry to see whether, you know, like depending on how the courts go on that question, you give more certainty for gaming companies or not.
Yes, I agree. I hope we'll see these arguments and we'll see this develop more in different jurisdictions. But what, like, coming back to the policy argument, I agree that it's also like sort of like a political game that countries want to be like the trailblazers and saying like, well, Israel is a land of innovation and AI, but the question is where the rights holders are. If I'm an Israeli video game company as an IP council, I want to be like safe saying that, yes, we can use AI because our Ministry of Justice says it's okay. I know that I will get sued in the US because Warner Brothers is in the US and they will try to drag me to the court in the US. And again, the multi-jurisdictional problem is that the game is published in more than, let's say, 100 jurisdictions. And then fair use is just several countries, basically. When we think about not even common law countries, CIS, it becomes really, really scary because you don't have that well crafted exceptions there. And I worked a lot with CIS market, and I know that the answer to the majority of questions is like, most of the questions is just like, oh, it's a gray area. I mean, it has never been tested in the court there. And then the rights holders, they are not like, they're pretty experienced. They have pretty experienced legal teams. They will be like, oh, we see here like a possibility to litigate in these countries where copyright is extremely, extremely strict and basically not very flexible in terms of AI. So it's interesting to see how the policy will change in terms of like business policy, what the rights holders are going to do, where they will go to sue, and what the creative industries like video game industry will do in terms of like accepting this risk. Because I agree the video game industry generally has a pretty high risk appetite and risk tolerance. So they are more or less open to this innovative uses, especially in terms of cost saving. They are really eager to embark in this super dangerous adventure, you know, just to save money. But again, they are still not that risk-taking to use AI-generated works without any indemnity provision to cover you. So if Microsoft really wants to make more money on AI, so I believe they will train it better and then develop like a pretty broad indemnity provision to make companies comfortable to use it and know that they will not face litigation anywhere in the world, basically.
Thank you very much. I think it's time for us to open the floor for discussions and comments or questions from the audience. I know that we have colleagues from WIPO who are with us and who are working on certain of these issues. Perhaps one of them would like to take the floor and share with us their thoughts and activities and projects.
Thank you.
Would you like
Thank you so much, Professor De Vera. And I know Michelle is, of course, our expert on copyright. So, of course, she's the one who I'm sure would have any amazing comments to the presentations. And thank you, Professor De Vera, also for inviting me here, and to Amihut for this invitation. And today I'm just a fascinated listener to the presentations, which are all of them. The presentations and comments are really amazing, which makes me even more aware how difficult of a task do we have with our upcoming project. because at the end of the day, what we currently want to do in WIPO, we will be launching a new project in the upcoming days, which is aimed towards supporting the small game developers, the indie studios, in better understanding the basics of intellectual property. And here we will be approaching it in a way that we want to keep it to the basic things a small studio needs to know about IP, and covering these more kind of checklists and tips and tricks. So in other words, what Professor Trapova invoked are mastering the game, which is 400 pages of legal and business issues covering video game development. So here we want to distill that into just a few pages of checklists that the game studios will be able to put on their wall. I'm a lawyer originally, so I know how difficult of a task this is to do it. I can write hundreds of pages, but it's much more difficult to just write one page. And this is the task we have in front of us. But I think with the many amazing experts we have on board, we will be very close to providing something very useful to the game studios. But apart from those checklists that you will be able to put on the wall, we will also be launching a series of podcasts, which we will be interviewing within these podcasts, successful gaming companies, within these short 20-minute segments, and focusing on those business aspects of IP. And there we'll be following the different stages of game development. So the first podcast would be on concept phase, the second podcast will be on development phase, the third on launching the game, the fourth on IP audits. And Stacey mentioned already something I noted down for ourselves to perhaps include on AI issues for IP audits and the issue of the insurance companies. These are the kind of tips that we want to include within the project. And then also additionally, we also have a dedicated LinkedIn group, which we will be launching on IP and video game development. And anyone is free to join the group. And of course, we'll be, trying to encourage the game developers themselves to participate there. But we will also have many amazing experts, and we would be honored if you would also join and be part of that group. We'll also have side events and networking events, which will be announced through that group, where we will also have some talks on some of those more recent issues, for example, exactly gaming and AI. So there's a lot of things coming. I don't want to take the floor, and Michelle knows that if I start speaking about this project, it will take hours and hours of everybody's time, and we're supposed to be short. So I finish here, but within the upcoming few days, we will be announcing all the details. So have a look out at our webpage where we will have everything announced, including also, of course, on LinkedIn. And I know I have many of you on my network, so I'll be very happy if you'll be part of our network. Thanks so much, Professor De Vera, and congratulations again on these fascinating talks.
Thank you so much for sharing this fresh news, and we very much look forward to getting to learn about these projects that shall be released shortly, as we understand, and very happy on that front to continue the discussion at another occasion. Is there anyone else wishing to put a question to the panelists or make a comment about what has been said? I don't see anyone. I just wanted basically to share two things on the chat. One is, I think, Philippe, you alluded to that. It is basically using AI to cheat. And I was curious to see, also knowing, and perhaps I should add a third link if I can retrieve it, which is, and perhaps I can even share my screen if you can do that, which is about ongoing litigation. As I'm sure you know, and without entering into the details, a question which has been referred to the Court of Justice to clarify under copyright law to what extent you can use somehow the existing copyright framework to fight, so to say, against cheating. And I'd be curious to have the views of everyone, and specifically of our speakers and panelists on this issue. And the other one is just perhaps a comment also a question to all of you, and Philippe, also you said earlier that, and that's what you also said, Stacey, is basically that the industry is not reluctant to litigate and to fight. My question is, as you can see on the second link that I shared in the chat, is basically whether you think there might be kind of a specific role for ADR and more specifically for arbitration in this context. Of course, we know the limit in the sense that there should be consent. Also, perhaps to overcome, and that goes to what you were saying earlier, Alina, which is kind of obvious, as we all know, is to kind of avoid the kind of a fragmented approach, country by country application of the law, where we may end up in kind of having some kind of a global level playing field in order to avoid the discrepancy between the local law. Of course, I'm fully aware, and I stop so that you can have a chance, of course, to react, but we all know that this cannot be kind of a one-size-fits-all solution because it can only apply under certain circumstances. But I was wondering, to that second point, whether you think that something might be done on that front. As you will have seen on the second link, this is basically what WIPO offers the colleagues from the WIPO Arbitration Mediation Center with the specific rules for video games and also esports. Any thoughts on any of these issues?
Sorry, Dr. Trapova, please go ahead. Yeah, I'm sorry. Yeah, my dynamics with Zoom is it's been years. I still, like unmute and mute myself. Yeah. But Professor De Vrij, in terms of cheats and the role for mobile gaming companies, this is major. This is a major preoccupation for companies in several regards. Cheats are so abusive behavior or inadequate behavior by players is expensive for companies. It's from a very practical perspective. It's expensive. It harms the user experience. You have dedicated teams to solve it. Different games have different issues, and it's extremely hard for companies to do that. It's a number one priority for most of the companies, and the gaming industry is moving towards more immersive games, multiplayer games. That's more troublesome by the day. And in terms of litigation and arbitration, the WIPO path towards arbitration is an excellent one for companies. And is one that I'd love to see companies pursuing more and more instead of litigating, going to court in the US and so forth. It puzzles me why this isn't even more widespread and companies haven't adopted it more. It's beneficial in terms of cost, in terms of length, public relations. My take would be a very practical one that maybe companies are engaged with outside counsel. They have specific dynamics that worked for them, and it isn't sometimes part of their internal dynamics to move towards arbitration. But it is something that I've been hearing IP counsel talking more and more about, and I'd love to see disputes going into that path more and more. So very practical considerations, I guess, from my end.
Thanks very much. Who would like to react then? Alina?
I don't have much to say on the German case, the Court of Justice, because I want to see what the court says, aside from the fact that Germany is proving to be the front runner in gaming and copyright litigation. There's been a lot going on in terms of exhaustion and copyright and video games and platforms and selling keys and all sorts of copyright related things, which some have remained on a national level, and then others have prompted discussions internationally. But it is interesting to see how that will develop. I think the ADR path is excellent, especially when it comes to indie companies. I think I totally agree with what Philippe just said, that maybe big companies have a very strong relationship with their councils, and that is not always going to be the path suggested. I don't know. I don't want to dive in that because I don't want to just guess what the answer might be. I don't have direct experience with that, but that will be my guess here as well. So it will be very helpful for those companies who actually don't have the backup of a strong external counsel. And on top of it, I think actually I am not a big fan of cases going to court and us getting actually clarity on the law through the courts. It would be great if things are clear before they go to court. But having a good ADR mechanism in place might be able to shed that light that one would get if the case goes to court, but in a more amicable, in a more balanced manner, if that makes sense. So resolving the dispute between the parties through alternative dispute resolution, instead of actually going all the way through an expensive and costly litigation, still helps us shed light on the topics. And we need that. I mean, we can't just guess what may happen if the case goes to court. I keep telling my students, oh, this happened and they settled. And students get so disappointed because they want a clear answer. So maybe here we actually might have an opportunity for some clearer answers. And that's my views on this so far.
Thanks so much, Stacey. Any thoughts?
And just a really quick comment and the cheats and alternative dispute resolution. So I don't think that AI will tremendously change the landscape of what we call cheating, because currently we have several arguments being made. It's like circumvention of technical protective measures if you use cheats which help a player to basically overcome the rules of the game, like shoots through the walls, which become transparent, et cetera, et cetera. However, if we have an AI which basically plays instead of the player and just accumulates any in-game currency, so-called like boost an account, and then people will just sell those accounts on the gray market, which is also happening now, but it's done by people and then can be done by AI on a like really more efficiently. It's also like the arguments will be still the same, so it will not change anything significantly for lawyers. And I think that contractually we'll see more and more terms of use saying that any use of AI in the games or AI enhancements for players are prohibited. So we will most likely see this in the terms of use to basically prohibit this type of cheating. In terms of alternative dispute resolution, I see that for many companies, when they go to the court, their relationship already went sour. So they're in a really bad relationship with a partner or a company developing like a copycat of your game. And companies usually try to settle, try to negotiate before the litigation. And then the problem is if you already go to court, companies want to have some certainty with regard to interim measures, how they're going to enforce this decision, and also like rules of procedure. So will there be a discovery? How am I going to prove that they copied my game if I cannot force a discovery in alternative dispute resolution? So it also matters, like these like small things of procedure might be decisive for video game companies when they're in a really deep contradiction with a copycat developer or a partner. So I think this can be the reason behind not really high popularity of IDR between video game companies.
Thanks very much. I think we're getting almost to the time where we're supposed to stop also, because some of us have other commitments. Last opportunity for the audience or anyone to make a point, final points, also to our speaker and to our commentators. Any final points to make, knowing that obviously the discussion cannot lead to ultimate solution. This is, of course, a highly dynamic environment, as reflected also by this ongoing litigation in Europe, in Germany, which has been indeed kind of leading the way, at least from a European perspective, on certain of these challenging issues. Any other comments? So time for me just to briefly wrap up by thanking everyone for their participation, specifically, of course, our speaker, Alina Trapova, as well as our two commentators, Stacey, Chuvaieva, and Philippe Sundfeld. What strikes me, of course, I will not attempt to summarize what we discussed, but what is interesting to me is that if I try to take one step back, is that perhaps we should look at the gaming industry as defining the future of copyright law. You think it is in terms, and that was alluded to and mentioned, and you were right in doing so, Alina, by saying that this is, as of today, most probably the most important industry in terms of money, which is at stake. Also, it's interesting because it combines, as you said, technology and artistic creativity, and also because it combines kind of this very challenging issue, which is to find the right balance between the control of the gaming companies and the creativity that somehow needs to be granted to the user. So the kind of in-game creativity or more general creativity. So how do you balance, which is somehow representing what happens or what seems to happen even beyond the game industry. So it's going to be interesting to observe what will come and what might be developed in that specific industry, and to see to what extent that would lead the way to be applied more broadly to all other sectors of the copyright industry. So this being said, many thanks to all of you, and also last but certainly not least, many thanks to Amir Joseph, who has been helping me for that session as well as for the other session of AITPT. We very much look forward to welcoming you again at a future edition of AITPT. In the meantime, we wish you all the best, and thank you again very much for your kind attention to the program. Thank you.
Thank you very much.
Thank you.